Hello, hello, hello. Welcome. I am Fred Feliciano, the CEO of Critical Conversations HR. And today we have a very special guest, and I will bring him up now. Jack, how are you?
Doing well, Fred. Thanks for having me.
Oh no, thank you for coming on. I have to be honest with you, though, Jack. Typically, when I'm chatting with an attorney, you would be the last person who I would want to chat with and hear from and communicate from. But in this
What?
circumstance, I'm grateful that you're here.
Well, you may need to explain why that's so.
Yeah, so from the HR standpoint, when we get a letter from an attorney or get a call, it's typically not a good thing. And typically it means that we may have done something wrong from the
I
HR
see.
point of view.
Got it. Okay. But you do
Thank you.
concede from the HR point of view that people who feel they've been treated wrong should have access to workplace justice. I take it.
Absolutely, 1,000%. Thousand
Okay.
percent.
All right. So good. We're in agreement.
Yes, yes, yes. So maybe Jack, maybe you can tell the audience out there who you are, what you do, and tell us about your practice.
Thanks, Fred. Well, my name is Jack Tuckner. I am an attorney admitted to practice in New York and Connecticut. I have been since 1998 an employment lawyer. Prior to that, I spent 10 years as a criminal lawyer, as a public defender in the Bronx, which is a part of New York City, and Manhattan, which gave me a lot of trial experience and gratification because that was where I got to hone my trial skills, and I'm representing the underdog. That's kind of my focus has always been who needs the assistance, who needs the empowerment, when I went to law school, the only reason that drove me, and I didn't go right through school to law school, I never wanted to be a lawyer. I hated lawyers as much as the next person for good reason. At the time that I decided to go to my law school, which had just opened, it was the City University of New York Law School at Queens College, a law school dedicated to law in the service of human needs. That is its motto still. That's on my law diploma. It's about people over profits. It's about individual championing individual rights. That's not what most lawyers do because it's kind of not where the money is, frankly. But when I went into it was expressly to be a lawyer to represent people who wouldn't otherwise potentially have access to justice is the short version.
Got it. Got it. And in terms of this niche that you're currently in, what was the motivation behind focusing on women's rights in the workplace? Is there a
Well,
story behind that?
there is a story behind it, but to be brief or to try to be succinct about it, may not be of interest to everyone but people do say to me, "What are you?" Especially now, "What are you, an old white guy? You're a women's rights lawyer." Well, when I had spent 10 years, as I mentioned, as a public defender. It's very challenging. It's sort of burnout work. You get to a point where it was like, okay, what's next for me? I'm trying 12 cases a year. It is particularly enervating and can be difficult, especially, fortunately for me, I had an 86% acquittal rate, meaning most of the time I won. But when clients are convicted, when they're sent away for, nonviolent things like back then, the Rockefeller drug laws were draconian. People were getting life sentences for, handing someone a controlled substance that the other person wanted. Um, I was asking myself, where is the need? And because I grew up in a matriarchal household, women were the dominant force in my life for the good. I always saw, really what kind of right since I was a child. When I was a kid, my mother couldn't get a credit card without my dad's co-signature. This was true for those youngins out there. This was true until 1974. Women needed a man to get access to credit, to get open a line of credit in a bank, to sign for a mortgage. It's unbelievable. So I thought, and I was actually in Hawaii at some seminar was actually a Tony Robbins seminar, and I had an epiphany on this mountaintop in Kona, Hawaii, where I was asking, like, what's next for me? And you know what, the sort of the voice, the epiphany came, well, you know what the largest majority minority is in this country? Women. Unequal pay, pregnancy discrimination, sexual harassment, gender pay disparity. There are numerous instances where women are, and again, I represent men as well. Clearly, I represent people in other types of claims because at heart, I'm an employment lawyer for employees. I'm an employee rights lawyer. But my concentration over these many years, starting in 1998, were women's issues in the workplace. And it's just been, very gratifying. So for me, it still seems women have it much tougher than men in the workplace. Brown and black women have it much tougher even than white women. It's not a level playing field. And that's what still floats my boat and kind of gets me up in the morning and makes me excited about coming to work and representing the women, the clients that I do.
Okay.
Does that make sense, Fred?
So, no, it does. It does. So one thing I've dealt with in 25 years of doing HR are employees who inappropriately use the term harassment and discrimination. If you tell an employee to do a certain task, it's, they're feeling that they're being harassed. So maybe if you could for us, I have a two-part question. Could you maybe define what is discrimination and harassment, and then maybe go into some of the most common examples of how you've seen that manifested in workplaces?
Great question. Well, first of all, let's assume that we're talking about at will employees. And for those who don't know what that term means, at will employment, it's what most of us are. It's 90+% of us these days. Wasn't so 20 years ago, 25 years ago, when there was far more union membership. Because if you are a member of a union, there are at least some rules in your collectively bargained agreement that an employer has to follow. But in general, for most of us, and even for union members, if you work for a difficult boss who's yelling and screaming and bullying you, bullying is not illegal, by the way, in general, anywhere in the United States, unbelievably, but it's true. So if your boss is yelling at you or is harassing you, it's not illegal if the company can claim that he's an equal opportunity harasser, right? Meaning that he's a jerk. He's a jerk with everybody. That's his personality, but he's not picking on you because you're black, brown, female. He's just a tough taskmaster. And you know what? There's no law against that. The identification of discrimination and are you being treated differently? Are you being treated differently? Are you being harassed because of some protected status? Are you being harassed or treated differently in the workplace in the terms of the conditions or the benefits or the privileges or the pay of your employment because you're a woman, because you just came back from a disability leave, because you asked to be paid what you're worth, because you objected to unwelcome sexual advances, right? Because you're black, because you're brown. And by the way, those microaggressions in the workplace for people of color, I mean, they're real. Okay, I'm just saying, racism, sexism, definitely a thing. So what one has to identify before one just, you go home to your family and you go, work sucked today. It was just horrible. And my boss is busting my shoes. And then your family says, sue them. That's illegal. Unfortunately, it's actually not illegal. There's no such thing as a general toxic work environment or general hostile work environment. If your work environment is hostile, but it's sort of generally hostile, or you just say, I don't know why, but I can't stand it, you really don't have a claim to leverage. What you have to ask yourself is this happening to you because you're a man or a woman? Is it happening to you because you're perceived to be or actually are, because of your sexual orientation or your gender identity? Is it happening to you because you're over 40? Is it happening to you for some reason that you could identify? And that's illegal. That's protected harassment and discrimination. If you know.
So it seems you said two words that are very important, and that is because of. So if you have a behavior, the motivation behind the behavior has to be because of a protected category, correct?
Well, Yes, or at least it doesn't have to be that that's the motivation. It has to be your perception of the
Perception.
motivation, because it's always not really about proving this necessarily. It's and I'm a big proponent on the empowering exercise of not waiting till you're fired or waiting to quit, which is another
Mm,
story, because then you're in a completely different position if you haven't complained. So the I'm sorry, what was I just lost the thread of that follow-up. What was that follow-up question? Oh, yes,
yeah,
I'll
the
just tell you
follow-up.
what. Well, I tell you what, I think I just recalled. The follow-up, you can be fired when you're pregnant, when you're black or brown, when you're 52. You just can't be fired because of those reasons or because you complained of those reasons, because that's retaliatory and that's illegal. So you have to keep in mind that one of the pro tips for employees, as if you feel that you are being treated differently, listen, I don't have a high bar for that. If you feel that this marriage can't be saved, if you feel your work environment is unjust, if you have a disability and they're busting your chops about it, if you're being treated differently for any reason, which happens all the time in a society like ours, particularly with regard to sex, race, color, and national origin, and age, and all of them.
Mm, okay.
It has to
What
be
mis
that you're complaining that this is illegal treatment because of that. Because the when part, if you fire somebody when they're out on maternity leave, for example, and you go, wait, that has to be illegal. Well, not necessarily. Not if they're eliminating your position. Not if it's actually nothing to do with your pregnancy. And the company can say, listen, we're not hiring a non-pregnant person to replace you. We're just eliminating your position. I mean, that's the shorter answer to that question. Follow up.
Sure. What mistakes do you see employees make that hurt them when they're dealing with being harassed at work?
Well, the principal mistake employees make is not documenting it. This is
Mm,
so important that if you're this is a big unforced error. If you're being harassed or discriminated against or treated differently because of a protected status, because of who you are, then you don't complain to your company, whether HR, if they don't have HR, a boss, somebody in upper management, that's a mistake and that's a problem, because if and when then the company fires you, whatever reason they give, it's not going to be we're firing you because of this reason. They're going to come up with some other reason, but that reason is going to be accepted because your company, here's the reality. The companies are presumed to be innocent. I'm appropriating that word from the criminal law because it's
yeah.
true. Companies they're allowed to fire you at the drop of a hat. They don't have to give you notice. They don't have to do progressive discipline unless it's in the union contract. They could just say, "Listen, it's Christmas Eve. Sorry, our timing is bad. See ya. Wouldn't want to be ya. Don't let the door hit your butt on the way out." And you know what?
Mm,
They could have HR, or the security escort you out onto the street with all your belongings while you're weeping inconsolably and the Christmas party is raging inside. And while it's sad and infuriating and apparently unjust, it won't be illegal unless you can identify a reason for it, because they're allowed to. Here's what employment at will means: you could be fired at any time for any reason or for no reason at all.
mm,
Not a good
got
thing,
it.
but that's reality.
Correct. Oh, by the way, your camera went off.
Okay, let me try to get
Okay,
it
there we
right
go.
back on. Hold on. Here we go. Here we go.
There we go. Perfect. Okay. So, Jack, you had mentioned a keyword, and that keyword was documentation. From the HR point of view, I'm sure you've heard of HR managers, HR directors documenting every single thing that their employees do, attempting to build a case against that employee. But in terms of from the employee perspective, what is good documentation for the employee to have that will help them when they eventually come see
Well, that very paper trail I'm talking about is that if you,
you?
let's assume you don't wait until you're put on a performance improvement plan, Fred, right? Because this is the thing. If you're put on a PIP, right? If your company says final notice, Or if your company fires you and then you say, that's not right, you're firing me because I'm black or whatever, you're kind of a dollar short and a day late because the
Mm,
company has gotten the jump on you. They fired you. They're allowed to fire you. Who wouldn't believe that reason? They could then say, you're just disgruntled. This is sour grapes. Of course, you're angry that we fired you. And now you're just pulling the race card, pulling the sex card, pulling the whatever card. So what's really important, because it's all about the timing, is if, let's say you have an unblemished record at work, but you're experiencing discriminatory treatment, even if you just you intuit it, you sense it, you feel it in your bones, but you don't really have proofs. Nobody's called you an epithet, a name, but you can point to, I'm being treated differently. I'm being paid less than the guy across the way who's performing substantially similar work to me, or I suspect that he is. You would want to document that because your complaint, your documentation is considered protected activity under federal law, and in my case, where I principally practice in New York and Connecticut, but under New York law, under federal law, under New York state law, under New York City law, if you complain, that's protected activity. And what the company is not permitted to do is treat you worse, subject you to backlash on the heels of that protected complaint. That's called retaliation. Retaliation is illegal. I'm not talking about the English word, just I'm going to retaliate against you. I'm talking about, pardon me, that's a legal concept. Retaliation for a civil rights complaint in the workplace is illegal. So that gives the employee the leverage, right? That often sets the company, as you may know, Fred, and with all due respect, might take the position, we typically say that HR, and they're great HR people. I have great HR friends, but they're not really there for you. They are company men, so to speak, right? They work for the employer. They're not neutral arbiters of the fact. So the better paper trail you have, if you have a text, if you have proof, you want to give that to HR, because even HR sometimes scratches their head and says, this is a problem for us. What are we going to do? We should implement corrective action, right? Sometimes you do that.
yes. Yes.
So the documentation is, this is the slingshot that we as David have to the company's Goliath. And the idea is pinging the company in the forehead with your protected complaint. And that gives you the juice, as my daughter says. It gives you the leverage to hold your employer accountable. And if they don't do the right thing, as you also know, Fred, that can open the door to severance negotiations where your company may pay you to part ways as long as you sign a general release of your legal claims, and often a non-disparagement agreement, which has value to your company. And then you could feel that you held them accountable and could ride off into the sunset with a package and move on to the next position, because, suing your employer takes years, and it's not what people think from watching on what happens in Boston legal episodes or in Hollywood movies.
Mm. So many employees don't want to deal with a hostile work environment. A lot of people have anxiety. Even people who aren't being harassed have a hard time going to work on Monday mornings. So you have a lot of employees who quit instead of doing something about it. How can quitting hurt or help someone's case of harassment?
Well, quitting is bad. As I've said for years, quit is a four-letter word for us plaintiff side employment lawyers. In fact, the first hashtag we ever used on Twitter in 2009, I believe, was hashtag don't quit. Because what people do is they say, this sucks, I can't stand it, they quit, then they call a lawyer. And at that point, quitting is like throwing out the baby with the bathwater. You
Mm,
are even you can't even collect unemployment benefits when you quit. The Department of Labor will say you voluntarily abandon your position without good cause. And you say, but I had good cause. Yeah, but you gave up your job. So the idea is there tends to need to be an so-called adverse employment action. So I'm not saying you have to wait to be fired, but if you have another job waiting for you that pays more money, of course quit. Then you ride off into the sunset, take your better job, and don't worry about it. But why would you quit? Don't quit if you don't have another job lined up. because you'll just be unemployed and your case will be substantially weaker. Most of us employment lawyers for employees don't go to trial on quit cases for these reasons.
Yeah.
It's just too difficult to
Okay.
surmount that, to get past that notion of you're the reason you don't have money, the reason you have a year's worth of back pay damages is you walked away. So don't do that.
Okay. If someone is a victim of harassment, when is the best time that they should pick up the phone and contact an employment attorney?
All right, so I froze here. Let me just try
Yeah.
to
Okay.
let me just do this again. 1 second. Sorry. I will just hit this again. And now I'm going to come back and see if this works better. Am I
Perfect. We
back? I'm
see you now.
back, right? Okay,
You're back.
thank you. So,
Awesome.
sorry, what was that question? I apologize.
Yeah. I was saying that when someone is being harassed at work, when is the appropriate time for them to reach out to an employment attorney?
Well, anytime. First of all, the idea is that if you don't know what to do, and if you want some advice, many lawyers like me, many, again, plaintiff meanings employee lawyers, there's probably more lawyers that represent management than there are lawyers who
Mm,
represent employees. But you want to reach out to a firm that concentrates in labor and employment to get advice. What should be in this letter? Do you need help from behind the scenes? Do you need a pep talk? Do you need someone to help you with that framing of that language? That's often helpful. But you don't need to do that if you just complain, as imperfect as it is, but you mention the words discrimination and what you think you're being discriminated, why you think you're being discriminated against, meaning you're naming a protected status or activity. Like, I just took maternity leave, and then when I got back, things went way down south. That's that's illegal. You would want to just document that and say, ever since I got back from maternity leave, or even before I left, my boss was doing XYZ, treating me differently, and now I don't have the same job I came back to. It's discriminatory. It's
mm,
sex, pregnancy, and disability discrimination because your maternity leave is a disability leave. So sometimes you may need to speak to a lawyer to help you navigate these issues. If you're still employed, some lawyers, myself included, depending on your salary level, depending upon the level of what you're dealing with, might need to charge you for their time. But much of the time, if a lawyer takes your case with a view towards saying, I'm going to write to your company, I think you're being discriminated against, and I'm going to either try to get you out with a package, or if you've already been fired, I'm going to threaten to sue them and maybe actually sue them. Many lawyers take those cases on what's called contingency basis, which means on spec. It's a risk reversal. Lawyers work and then they take typically 33.33% of what they can get for you in a settlement. But I think that might be too much information in answer to your question.
no, that's perfectly fine, perfectly fine. I want to, for a little bit, I'd like to shift gears into the employer perspective and ask you some questions about how employers can protect themselves. Um, in your experience, what has been some actions that hurt an employer's ability to defend themselves against complaints and litigation?
Well, it's first of all, I don't typically represent employers except occasionally with small employers and never in court. But I do mediate for, again, smaller employers. The larger ones would do well to not come to someone like me, and they have the bigger firms. But from
Yeah.
what I see from the plaintiff side, it's the same thing I'm saying about employees. If employers don't document, I spoke to a woman this morning. Her boss, this morning, I had a consultation with a woman who's making six figures. She's worked there for 2 years. She has an unblemished record. Oh my God. Let me just hit this up again. Can you still hear me?
I do. The audio is
Yeah,
great.
I don't know why it keeps bugging out. Here we go. So she has an unblemished record. She had a promotion. She had two great evaluations. Suddenly her boss comes in and says to her, you need to resign. We want you to resign. This is going to be over in December if you don't resign. It's going to get ugly. You should resign. Why? No reason, but they're pressuring her to resign. and they're telling her that they're not happy with her, that she doesn't look happy, and therefore she should separate. Now, what's the problem with this? And one more piece, this
Mhm.
is someone who has an approved FMLA leave starting in December, going through January for her knee surgery. So this is a mistake the employer made now. They they told her that she needs to quit or she's going to be fired directly after they approved her FMLA leave for a disability. And they have nothing on her. So they have a problem now, because how are they going to defend that? It wasn't like they had a bunch of emails to her evaluations that said, you better shape up or ship out, sister, right? They have nothing on her that's a legitimate, non-discriminatory reason to let her go. So they're going to be up against the ropes when she does now what I advised her to do, which is complain about this, and I will back her up. But she still needs to be the first one to put the balls in HR's court. And again, you know this, even though this might not be something that as an HR person that you would tell someone to do, because HR doesn't want it in writing. You don't put these things in writing typically. But you're asking me as an employment lawyer
Mhm.
what I would say. And the answer is employers should do the same thing. They need their own paper trail. If an employer has somebody and we're not happy, we're not happy, we're not happy, now you're on a performance improvement plan and you've got 60 days to get your, by the way, performance improvement plans, most people don't recover from. So you don't want to wait.
Correct.
The performance improvement plans are used by employers to performance manage someone out the door,
Mhm.
except for the rare occasions if you're like a factory worker and you're supposed to produce 50 widgets a month and you're only producing 40, and your company says, hey, you're falling behind, you better start getting to 50 every month, and you get to 55 the next month. They probably relent and say, well, it's objective, you did it, so we're good, you're good. But most PIPs are subjective, especially on higher level jobs that aren't manual labor. So if your performance improvement plan says, we don't like the way you roll, we don't like the cut of your jib, you're just not doing it for us anymore. It's very difficult, and giving you 60 days. Now you're demoralized. Now you're upset because they put you on like probation, and that's going to likely end in your separation. So this is why it's so important to beat the employer to the punch. If you have complained about discrimination on Monday and on Friday they put you on a performance improvement plan, you're in a good position now to call that performance improvement plan retaliatory.
Mm.
And that has a lot of weight, as you may know,
That's a
in
very
terms of,
scary word, Jack. It's a very scary word when we hear retaliation.
right. Well, the reason that's retaliation is often worse for employers than discrimination, which is why it's a scary word to management, is that
Mm.
retaliation claims are the money shot. Meaning, it's the discrimination. If you're discriminated against for a year, where you just go, you know what, I think they really, I'm a black woman, dealing with lots of microaggressions. It's subtle, but it's insidious. I know it. They don't take me seriously. They talk over me at meetings, blah, 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 right? That's difficult, right? You have emotional distress because of it, but you haven't lost a dime. And again, it's sort of hard to prove. But if you complain about that microaggressive racism, and then you're fired on the heels of that, there's a
Mm.
legal term for that, as you know, in close temporal proximity to the protected complaint. If you're fired or demoted in close temporal proximity, is a fancy way of saying close in time. Sorry, let me do this again. If you're fired close in time to your protected civil rights complaint about racism, well, now you're out of a job. So now the meter is running on your back pay damages. So you've got more leverage again to hold your employer accountable, because you're going to say, until I replace the income with a similar comparable job or a better position, you're going to owe me this money if we go to trial and I win. And most employers know that it doesn't really matter the outcome of a trial. They're going to spend hundreds of thousands of dollars, win, lose, or draw, defending the claim. So most employers don't want to do that, don't want to have to pay their lawyer $800, $900, $1,000 an hour, which is what lawyers for New York cost, to defend the claim when they could resolve it for an amount of money that the lawyer is probably going to ask for in their retainer agreement, just up front.
Okay. Let's talk about pregnancy and employers. What are some considerations that employers have to know about when dealing with an employee who comes to you and she says, "I'm pregnant"?
Well, this is a great question. This is my favorite topic and my favorite cause of action, because for me, pregnancy cases are still the number one claim that I bring out of this office, because that's how I started. I teach other lawyers in continuing legal education seminars how to successfully bring pregnancy claims. And I've been banging my head against the wall for decades, educating opposing counsel, educating clients about why they would say, for example, your client, pregnancy is not a disability. Your client's not entitled to maternity leave. If she's not qualified to take leave under the FMLA, for example, because she hasn't worked for us for a full year when her baby was born, and she only has 10 days of accrued PTO, what? We don't have to give her leave. There's what law? What law? There's no law that says that. And I would say to them, yeah, there's a law that says that. There are several laws that say that. She's a woman. It's only women, so it's sex. She's unable to work for at least 6 to 8 weeks postpartum, because even insurance carriers that never give away money consider a woman after a vaginal delivery to be disabled for 6 weeks minimally, 8 weeks after a C-section. So if you're disabled for that period of time, how can you say you wouldn't accommodate her? If a man or a woman broke their ankle or had COVID or a heart attack and they only worked for you for 3 months and didn't have accrued PTO, are you going to say you can't take disability leave to recover? No, it would be disability discrimination. So we used to argue this all the time. It is an intersectional sex plus claim. I would win many of them. I know I talk about like what claims. I have one of those as my favorite, justice claims, when we kicked an employer's butt over this very thing, and they realized they had screwed up because they made this exact argument, which was recorded by my client legally, and it was completely illegal. Now we finally reached the promised land, in that as of June 27th of last year, 2023, we now have the Pregnant Workers Fairness Act. It took 20 years to get, but that's law federally. So everywhere in the United States, as long as you work for an employer with at least 15 employees, and that's most employers, not the mom and pop shops, but that's a lot of employers. The law now says that your pregnancy is a protected status, period. You don't need to have a pregnancy-related medical condition. You don't need to have gestational diabetes or hypertension. You don't need to have a high-risk pregnancy where you're bedridden. You're pregnant, you're entitled to flexibility. You're entitled to reasonable accommodations throughout your gestational cycle, and you're entitled to a reasonable period of time to recover from childbirth, and you're entitled to come back and lactate, express milk in your workplace. They have to, and it can't be in a bathroom. They can't put you in, an unlocked. It has to be a private, non-bathroom space with a door lock where you can express milk. And in New York, you have 3 years postpartum to do that, and you get paid for that time. Under the federal Pump Act, it's on your time for the couple of 15-minute breaks you take need to be off clock, and you need to be returned to your position or a substantially similar position. So now these days, while not every employer is fully aware of this, if you're pregnant, you're in a protected space and you are entitled to flexibility, maternity leave, and during your pregnancy, if you need to see your OBGYN, if you need to get sonograms and other further testing, your employer has to be flexible with you. But again, it comes back to the onus is on you, the employee, to document this. And one other little tip, when you're pregnant, when you first learn you're pregnant, when do you announce it? How do you announce it? It's a good question, right? When you're pregnant, not every, you shouldn't, most people know this, or their OB-GYNs tell them this. You should wait until roughly the end of your first trimester to even announce it to your family. Back in the day when my wife was pregnant with my oldest, and I'm going back decades, we were at a wedding and she made 300 people and we were so excited about it. I announced it. I said, she's pregnant. My wife's,
Yeah.
and everybody was like, oh, mazel tov. She had a miscarriage and then a
Mm.
DNC. You know how
Wow.
much more emotionally painful it was to tell everybody that. So you should, most obstetricians will say the pregnancy is far more stable around the time of the end of the first trimester. But before you're showing, if you work in person, because you don't want them to see it or get wind of it before you tell them. So
Mm.
generally, before you're showing, you want to announce it in writing.
Mm.
It's an important tip that it doesn't have to be a big deal. You could just send an email to HR or to benefits saying, we're so happy, congratulate me, I'm with child. I'm just wondering about the company's maternity leave policies because my due date is thus and such in 6 months. Just want to let you know. That's so vitally important because so many women, after companies learn that they're pregnant, companies don't really like that. It's a pain in their butt. They know that you are entitled now to flexibility. You need to use the restroom more. They have to let you do that. You need to eat at your desk in a company that says you can't eat at your desk, but you have morning sickness. They have to let you do that. You stand up all day in your job, you need to sit down. They have to let you do that. You sit down all day, you need to stand up and walk around because you get stiff, orthopedic issues, you've gained 35 pounds. They need to let you do that. So by putting it in, and to top it all off, you're going to be out for 3 months on maternity leave potentially. And so, and in New York, we have a paid family leave program, fortunately, where you get 12 weeks of about 65% of your pay capped at the New York State average weekly wage. But it's money. Federal law doesn't yet offer that. We're the only country in the industrialized world, essentially the only country on the planet that still doesn't think it's important enough to pay women to pay men and women for parental leave, right? Like we're supposed to be the family values country. We don't walk that talk, right? But I digress. The point is you want to announce it because to a company, it's profit oriented. There's all profits over people. So to most companies, if they are looking to replace you because you're pregnant, because you're now kind of high maintenance to them, you want to make sure that you have documented that you are pregnant so that they can't, if you didn't announce it, and then they just get wind that you're pregnant and then they write you up for something, right, as a way of managing you out, right? You're closing the barn door when the horse is already kind of galloped away. You're kind of a dollar short and a day late again, right? So
Mm.
pro tip.
Yeah. Yeah, and that's one thing from my perspective that I've been seeing is that employees, women have been notifying me in terms of, their expectations of delivery maybe 5 months before their due date, 6 months before their due date. So employees are now notifying HR a lot sooner and asking questions about, FMLA. So I'm definitely seeing that from the HR perspective. Um, Jack, I want to be very conscious of your time, so I have 2 more questions for you, if that's okay.
Sure. Fire away.
Okay. Great, great. So my understanding, New York City's human rights law added provisions for height and weight protection. Just out of curiosity, have you seen people complaining about weight discrimination in the workplace? Have you dealt with that?
It's a brand new law. I haven't had a particular case on that. Now, in the past, I've had cases on that, which were so-called sex plus cases, meaning sex plus is a category of discrimination where it's sex plus another factor, sex plus race, sex plus caregiver responsibilities, sex plus age, etc. Sex plus, I've been representing women now in menopause cases, perimenopause and menopause.
Mm.
That's sex, age, and disability. These are intersectional claims. So, in terms of weight, I brought claims for women when they were objectified or, ridiculed for being overweight, whereas, similarly overweight men they're fine, right? It's just women. We had a case in a major private university where just such a thing happened, and her obesity was still a factor with her, in terms of her sex, and so as a discrimination claim, and she was able to prevail and keep them from doing that, and she's still working at this job. But I haven't had under that statute yet a height or weight claim of my own experience, so I can't tell you much more than what I just said.
Okay. Okay. From your over 30 years of practicing law, is there one case that you've settled and dealt with where you said, this is justice,
Well,
and you felt
it's a
great about
well, you know what the thing is, it's not always that dramatic. I feel that
it?
regularly. I feel that regularly. Now, do I have my thinking now as you ask that question, you know, going to trial in New York in the Southern District of New York in federal court with a 64-year-old woman who had a sex and age discrimination claim. She was making, she was a low hourly wage worker, so she wasn't making much money. And the jury gave her $1 million for her emotional distress and punitive damages, etc. So, that's one where you're like, whoa, that's justice, that's victory. But even the one I mentioned, many of these cases that took 5 years. And that was a lot
Mm,
of aggravation for the client. It's public. So if you're looking for another job, it's not the greatest look when a prospective new employer Googles you, which they all do, and then sees that you're suing, because it's public. Lawsuits are public. Seeing that you're suing your prior employer, they think to themselves, maybe we shouldn't hire her because we'll be next. She's litigious, right? So I find the biggest justice cases are the ones that we resolve fairly quickly through settlements. And the one that I was talking about earlier, the pregnancy case, this woman, I mean, we got her a 6-figure settlement, and the employer was like, my own law partner was like, again, explain to me where there's a claim. Opposing counsel said that this was a national employer. And then
mm,
finally, when we drafted an EEOC charge, excuse me, and were threatening to file it, they blinked and they settled with her. They weren't going to give her a job back because she lawyered up, and nobody does that because you just don't bring someone back when they've threatened to sue you. But they paid her enough where she felt, that's how I define it. Whoa, like I kicked their tush. This was justice. I feel great about it. They won't do this to any women after me. That was important to
mm.
her. You know, she had 2 daughters, and then this child was born. So she was, someone, I like representing women who are also feminists and womanists, and understand that. Anyway, I don't want to get up on a soapbox, but that felt particularly gratifying. We publicized that. It wasn't also confidential, so that was a good thing. Um, but most of the time when you settle cases, there's confidentiality, but that serves clients most of the time too, because again, you don't necessarily want to be branded as somebody who sues their own employer, if unless you're ready to retire. Does that make sense?
Yeah, it does. It does. So,
I'm
Jack, I
frozen
want to
again.
thank you
Yeah.
for your. It's okay.
Okay. Hold on. All right. Well, you could thank me in 1 second. Let me get back.
There you go.
Okay. All right. Oh my. I don't know what this is, but if you want, here, let me just go one more time, and then we'll. Oh, I see. I had on the wrong camera. All right. Well, if you're just
It's okay. Okay. So Jack signed off. I want to say thank you to everyone for being on the stream. Appreciated. A very special thanks to Jack for coming on and being giving of his time. We really appreciate it. If you found value in this live stream, in this video, please subscribe to the channel, like the video, and most importantly, share this with other people who may be able to benefit from it. Thank you. Take care.